I think I'll divide it into two parts. A, I think as a lawyer, and B, as a human being. And frankly, I think when we were growing up as children, our interaction with our father was very minimal. And we remember coming back from school and doing our homework, and our father returning around 8, 8:30, late evening. And after his dinner, managing about 10 or 15 minutes of conversation on cricket with us, because it used to be our favorite topic at home. And we used to go to bed, and life went on that way. I think as a lawyer, I had always heard, even when I was growing up, that he was a great lawyer. And only when I started practicing, I realized how much I had to learn. And I can say that till about 2006, he used to often travel to other high courts. Frequent appearances before the Andhra High Court, Karnataka High Court, and the Kerala High Court. And he'd be available and help us along while we are doing a matter. But I think we really benefited from his presence after 2006, sometime around July 2006 onwards, when he started to spend a lot of time in the office because he stopped traveling. And after 2006, he was, I think, because me and my brother Prakash were doing most of the matters in court. For the last 10, 15 years, you would have seen that my father's appearances were relatively fewer. And but the great advantage for us was, as we were doing matters, the amount of inputs that we got, and his wisdom as a lawyer, not only about what to look for while preparing for a case, but more importantly, what to anticipate when one is doing the case on one's feet. I think that assistance and that help for us was absolutely invaluable. And I can think of several occasions where I used to be leaving for the court. I thought I had prepared fairly well for a matter, maybe a couple of days of preparation. Let us assume the matter was on a Wednesday. Sunday and then Monday, Tuesday, some preparation will happen. And then Wednesday, assuming there was a final hearing, I'll be leaving for the court. And my father would be sitting on a particular center table which is there. Whoever has visited our office will know there's a center table. There's a table in the center of the large juniors hall. And he'll be sitting there and reading the day's newspaper. And as I was leaving for the court, he used to ask me, "Inniki unak ennada matter?" He'll ask. I used to tell him, this is what the issue is all about. And then, though I felt I had got most things covered, he'll say something out of the blue. He said, "Have you looked at this?" And it used to, more often, 99% of the time, it was something invaluable. And immediately I used to rush to the shelf and pick up that volume of the ELT or the STC or the Supreme Court cases, and there'll be something relevant there. And almost pat on the point on each occasion. And I used to wonder how this man was managing it. And the other thing was that, as I said, his ability to anticipate what the judge could pose as a question was unbelievable. And I remember, especially once, there was a matter, and he used to know the pulse of the court and what can be anticipated before a given judge. He used to be extremely accurate about his prediction. And I remember one matter that was listed at 2:15 before Justice Chandru as a final hearing matter. This was sometime in the year 2010, October. And I had read for about 3 days, and I thought I'd prepared a spiral bind, circulated to the other side. Everything was done. And I was about to leave for the court at 1 o'clock. And I was quite confident. And as I was about to leave, he again posed his question, customary question. So what is it all about? He used to say, "Have you had a look at this angle?" And I said, I was surprised. And I was wondering how it had missed me. And he said, this is what the judge is going to ask you within 2 minutes once you get up. And if you have not looked at it, there is no point in your preparation over 3 days. And he was brutally frank with his assessment of a lawyer's preparation, even if it was his own son's. And I rushed and picked up those couple of books. And when I got up at 2:15, and Justice Chandru was always 5 minutes earlier. And when I got up at 2:10 or 2:15, the judge asked me exactly what was predicted in my office at 1 o'clock. And I was absolutely shell-shocked and relieved that I was ready to go in the last minute. So as I said, his knowledge of tax law was remarkable. And I think his grounding on first principles was remarkable. And his ability as an advocate, I think we are all aware that several of us who are very good lawyers, but not as good advocates. Several of us are very good advocates, but may not be the same as lawyers. But I think Mr. CN had both qualities. He was a great lawyer and a great advocate. In the sense, his advocacy skills were remarkable. And the other thing which I remember him telling me the moment I enrolled, though I found it quite intimidating, this was an advice coming purely from a senior advocate to a junior. And he said, some matter before Justice N.K. Jain, who was Chief Justice at that time. This was around the year 99, sometime in the month of August. And I was, and Justice N.K. Jain was fairly a domineering judge. And I was quite intimidated appearing before him. I was only a few months old in the bar. And having prepared for a couple of days, the matter just fell flat and the writ appeal was dismissed. So I got back home and I got back to the office and I was kind of wondering, kind of licking my wounds and wondering what had happened. Because whatever preparation I thought I had been demolished in a couple of minutes by the judge. And he told me something extremely valuable. He said, in this profession, it's about 60% poise and 40% preparation. With 60% poise and 40% preparation will succeed. 80% preparation and 20% poise will fail, is what he told me. And I haven't forgotten it. I think I find it from several of our esteemed seniors, when they performed extremely well, I see that quality being replicated when they appear before the court. These are the few things I thought I'll share with you, his qualities as a lawyer. Now, as a human being, he had some great qualities. I think not just, we all know his, my seniors have spoken about it. I think Mr. Venkatraman had dwelt on it in detail. He was a very generous man, extremely noble man. But also, I think while we were growing up, he taught us a few things. The need for honesty, integrity, and also managing money. I thought he managed his affairs extremely well. And we are trying our best to be a small part of what he was. I think these are the few things I thought I'll share with all of you. He was a great soul, and I'm sure all of us really miss him. As a family, we really miss him, and his memories will stay with us. And on 2nd of June, this is his first anniversary. He passed away on the 2nd of June 2019, and we are a few days away from a year's completion from that event. So I thought I'll share these few things.
Thank you very much, sir, for sharing.
Yeah.
So now we can proceed with the session, sir.
Sure.
You using a PowerPoint, sir, or
no, there is no PowerPoint. I'm just presenting it across.
Okay, sir.
Yeah. topic which has been assigned to me is on section 19 of the Tamil Nadu Value Added Tax Act. And especially the impact of the amendment, which was effective from 29th of January 2016. I thought I'll just dwell on a few provisions and the position of law prior to 29/1/2016 before I actually get into the amendment. The Value Added Tax Act is Tamil Nadu Act 32 of 2006, and it was made effective from 1st of January 2007. Section 3.2 is the charging provision. Section 3.3, which according to me is part of the policy of the Act itself, says that the tax to be paid by an assessee will stand reduced to the extent of tax paid on his purchase. This to me is part of the policy of the Act itself, Section 3.3 of the Act. Apart from that, we have the definition of input tax under Section 2(24), and the relevant rule for the credit was Rule 10.2 of the Tamil Nadu Value Added Tax Rules. Now, the definition of input tax as it stood prior to 29/1/2016 is set out under Section 2(24) of the Act and is defined as tax paid or payable under the Act by a registered dealer to another registered dealer on the purchase of goods. So tax paid or payable under the Act by a registered dealer to another registered dealer on the purchase of goods. That was the definition of input tax under Section 2(24). Section 19(1) of the Act, as it stood prior to 29/1/2016, said there should be input tax credit of the amount of tax paid or payable by the registered dealer to the seller. And there was a proviso to Section 19(1), which stated that the registered dealer who claims the input tax credit shall establish that the tax due on the purchase has been paid by him in the manner prescribed. Therefore, the main part of Section 19(1), as it stood prior to 29/1/2016, stated that there should be credit of the tax paid or payable by a registered dealer to the seller, and the proviso required the purchaser to establish that the tax on the purchase had been paid in the manner prescribed. So the manner was set out under Rule 10 that provided for a tax invoice. Now, Rule 10 of the Tamil Nadu Value Added Tax Rules, Rule 10.2 to be specific, contemplated a tax invoice. The tax invoice is therefore a statutory document, and it was the mode prescribed under Section 10.2 to be furnished by the registered dealer, to be furnished as a document for claiming input credit on the purchase of goods. And it contained the following information: that the date of the invoice, the name, address, and the TIN number of the seller, the name, address, and TIN number of the buyer, description, quantity, and value of goods, then rate and amount of tax. So these are the elements which were set out in a tax invoice. Therefore, prior to 29/1/2016, as assessments were being made, a debate which went on was this. Very often, two types of cases used to come to the court. Cases where I, as a purchaser, had a tax invoice in my hand, and I took the credit in my monthly return, which is Form I return, on the strength of the tax invoice. Now, the assessment was a deemed assessment. The tax authority used to reopen the assessment under Section 27 to disallow the credit, essentially on two grounds. Ground A, that the seller was not registered, that the registration certificate of the seller had been cancelled though retrospectively. That was ground A. B, that the seller had either not furnished a return or had not paid the tax. This was ground B. When these matters came before the court, the submission of the SSE on 2-3 occasions was that in terms of section 19.1, the only obligation on the part of the SSE is to demonstrate that the tax had been paid to the seller and the tax invoice in terms of Rule 10 had been produced. That was the submission of the SSE. Department's argument was that value-added tax being a tax on value addition, unless the tax had been found to be discharged by the seller, no credit. That contention of the department has been rejected consistently by 3 judgments, which are often cited by us when we argue these matters. One is the decision, as we all know, which my friend Aparna had argued, Vinayaka agencies, now confirmed by division bench. Second was a judgment in Altaf shoes. Third was a decision in Infinity wholesale. Infinity also had incidentally been confirmed by a bench. Therefore, in these 3 matters, our High Court, initially single judges and recently 2 months back confirmed by a division bench, that once the SSE, as regards the position prior to 29/1/2016, which is prior to Tamil Nadu Act 13 of 2015, the law is that if the SSE demonstrates that the tax due on the purchase had been paid to the seller and the seller and produces the tax invoice, there is input credit. This is expressly stated in the judgment in Vinayaka agencies, has been recently delivered and by judgment dated 4th of March 2020. It's not yet reported, but it's available in our High Court website, webpage as writ appeal number 4292 of 2019. So this is, I would assume, the law now declared by the division bench in respect of the position prior to 29/1/2016. Now, the division bench also made an exception. The exception was what happens if the transaction is sham or bogus. If the veracity or the validity of the tax invoice itself is questioned by the department, will the production of a tax invoice still be sufficient? Usually it happens in cases where there's an investigation. There's a power with the Commercial Taxes Department in terms of Section 80 and Section 81 of the Tamil Nadu Value Added Tax Act to call for information either from the SSE or conduct an investigation otherwise, and call for information from any person or any authority. If the department has material to show that the invoice itself is not genuine or is representative of a transaction which is sham, that may stand on a different footing, was the exception made by the division bench in one paragraph in this writ appeal number 4292 of 2019, judgment dated 4th of March 2020. And I would think rightly so. But the real interesting question will be that on how does the investigation proceed if a case of fraud or sham is set up? Is it for the SSE to demonstrate that the transaction is genuine, or the department must have some prima facie evidence in its possession before it repels the tax invoice produced by the SSE? Can become an interesting question. Now, we must all remember that if the department, that the process of assessment under the Value Added Tax Act is a deemed assessment. Until 29th of July 2012, until 2012 July, the Value Added Tax Act under Section 22(2) provided for a deemed assessment by way of filing of a deemed acceptance of the return filed. In July 2012, there was an amendment. The amendment required prior to July 2012, it was a process of the assessing authority passing a deemed assessment order, but not questioning the return. After July 2012, it's a process of deemed assessment by the return deemed to have been accepted. But there's a power to reopen under Section 27 of the Act. If an allegation is raised that the invoice is representative of a transaction which is sham, how do the proceedings go forward? Is it first for the assessee to demonstrate that the transaction is genuine? Suppose the assessing officer issues a notice for reopening under Section 27 and says that there is prima facie conclusion that this transaction, or I suspect that the transaction is fraudulent or it's a sham. Is it for the assessee to demonstrate that the transaction is genuine, or the assessing officer must have material in his hand? Can be the question. Now, Section 27 also uses two expressions. It says first of all, conduct an inquiry. Therefore, an inquiry is mandatory in terms of Section 27 of the Act. Therefore, inquiry has to be conducted. And on conclusion of that inquiry, there must be some prima facie material in the hands of the assessing officer to show that the invoice is not genuine or is representative of a transaction which is in the nature of sham. Now, this understanding of Section 27, that an inquiry is necessary, in my view, is also consistent with the general principle that the person who alleges that a transaction is sham must establish it. When an allegation is raised in civil law, and tax being a type of civil legislation, the burden is on the person who alleges that the transaction is a sham. Therefore, if a case of sham is going to be set up, I would assume it's not the ipsi dixit of the assessing officer to say, I suspect the transaction to be a sham, because, for example, somebody can say, this is plastic trade. And in plastic trade, there is a general tendency of evasion. Therefore, I suspect the transaction to be fraudulent. That may not be sufficient. This is iron and steel trading. In iron and steel merchandise, I suspect the transaction to be fraudulent. May not be sufficient. There, in my view, has to be some material in the hands of the assessing officer to, first of all, let in a show as evidence to indicate that the transaction is genuine, transaction is not genuine, or is fraudulent. This flows not only from the language of Section 27, which requires an inquiry to be held by an assessing officer, but also from the general principle that a party who alleges the transaction to be a sham and will have to discharge the initial burden. Now the question will then be, is the burden constant? In other words, what will be the extent of material which the assessing officer will have to let in? Now, Section 17 of the Value Added Tax Act no doubt places the burden of proof on the assessee. The assessee will have to establish that the assessee will have to establish assessee has to establish that his claim for input credit is correct. That part will end up to the stage of deemed assessment. When the assessment is reopened and an allegation is raised that the transaction is make-believe, as I said, initial burden on the assessing officer. But in the course of the investigation, though the burden may remain the constant, the onus shifts. Once the assessing officer lets in evidence to demonstrate, maybe through some inquiry in terms of Section 27, or through an investigation under Section 18, and has evidence in his possession to show, for example, the evidence could be that the seller is not traceable. The evidence could be that though indicated as an industry, it's a small outlet or a 10 by 10 small shop, and nobody. So those circumstances may be indicative of the fact that the transaction is sham. That, in my view, may result in the onus shifting from the assessing officer to the assessee. Now, therefore, this principle in an income tax case, that though the burden of proof may remain constant, the onus shifts, is laid down in the judgment in Kalva Devadatta, which is AR 1964 Supreme Court, page 880. That principle was laid down that though burden of proof remains constant, the onus will shift. And it keeps shifting through the course of the trial or assessment and the truth will have to be assessed on the basis of the weight of evidence and preponderance of probability. So this, I thought, is probably the exception to the rule laid down the division bench that tax invoice is sacrosanct, because if the veracity of the invoice is questioned, even in respect of the period prior to 29/1/2016, then issues may take a slightly different color. So this is more or less the position with regard to the legal position prior to 29/1/2016. There is one other reason why the reasoning of the court, one other ground on which the reasoning of the court can be supported. The division bench took the view that production of the tax invoice is sufficient. That was in that writ appeal in Vinayaga agencies, where the department appeal was dismissed. Now, it is not unknown in a taxing statute that the statute lays the burden of proof on the assessee and also prescribes the mode by which that burden can be discharged. I'll give two illustrations. Section 8 of the Central Sales Tax Act states that if you effect a sale to a registered dealer, you produce a declaration in terms of Rule 12.1, which is a Form C declaration. Now, the Form C declaration is not just a condition precedent for a concessional rate, but is also a declaration as proof that the sale has been effected to a registered dealer. Section 6A of the CST Act, burden of proof on the assessee. If an assessee wants to say that I have moved goods from state A to state B and wants to prove that fact, the Central Sales Tax Act, Rule 12.7, also provides for a declaration. That declaration is F form. Now, once F form is produced, it is taken as conclusive of the state of affairs that there is no sale but only a stock transfer. I think the closest analogy which I was able to find was one Chunilal's case, where the Supreme Court dealt with Form 3A in the UP Sales Tax Act. And this Chunilal's case is reported as 1986, Volume 2 SCC, page 501. And in Chunilal's case, Supreme Court, while dealing with Form 3A under the UP Sales Tax Act, said once the selling dealer produces Form 3A, that itself is indicative that this is a resale and not the first sale, and may be taken as conclusive of that fact. Perhaps, though the Honorable Division Bench, the reasoning of the Honorable Division Bench can also be supported by the principle laid down in Chunilal, and will also place some emphasis with regard to the validity and the weight to be given for the tax invoice as regards to the period prior to 29/1/2016. This is more or less the position. Prior to 29/1/2016, production of tax invoice, payment of tax may be taken as sufficient for discharging the burden with regard to input credit, unless the transaction itself is questioned as sham by the department. This is with regard to the position prior to 29/1/16. So let's come to the subject topic, which is Tamil Nadu Act 13 of 2015. Now, as we saw earlier, there was one proviso to section 29(1), to section 19(1) of the Act. There was only one proviso. And that proviso said, the registered dealer who claims input credit shall establish that the tax due on such purchases has been paid by him in the manner prescribed. And the main part of section 19(1) said, there shall be input tax credit of the amount of tax paid or payable under the Act by the registered dealer to the seller. Now, Tamil Nadu Act 13 of 2015 introduced three changes in section 19(1). Change A was with regard to the main part of section 19(1). Earlier, the section said, we'll give you input credit of the tax paid or payable. After 29/1/2016, it is tax paid. In other words, earlier, for example, if the transaction is going to happen on credit basis, I raise a tax invoice, the buyer receives the tax invoice, and in being in possession of the tax invoice, the books of account showed that he was a debtor and had to make a certain payment of price and tax to the seller, he could nevertheless take the credit, though the tax got paid later. On 29/1/2016, change A is the credit is on the tax paid. Therefore, the tax must be paid to the seller. That's one change. The second change which has happened is the introduction of a substantive condition. The condition which is very similar to what we find under Section 16 of the CGST Act 2017 today. The conditions that the buyer establishes that the supplier of goods or the seller of goods has actually paid the tax. That's the second condition which is found, which is now there after 29/1/2016. The third condition is that as the buyer, I must also establish that the goods have been actually delivered to me. This change was actually necessitated because apparently the revenue found that prior to 29/1/2016, an extreme stand had been taken by the SSE that production of tax invoice was sufficient. And revenue was proceeding on the basis that in a sale there is delivery of goods. So unless one establishes delivery of goods, then a sale is not complete. And therefore, 19(1) has now been amended, requiring the buyer to establish that goods have actually been delivered to him. So there are three changes, as I said. Now I must point out one thing, that in the course of this session, I will dwell on changes A and B, which is on tax paid and payable, and on the substantive condition. As regards the third change which has been brought about, as regards movement of goods, I will have to say that the matter that a batch of writ petitions were heard a few months back by the learned judge, and judgment reserved in the matter. I cannot therefore canvass any view here. I can broadly indicate what were briefly the submissions of the SSE and briefly the submissions of the revenue in the matter. Because the matter is sub judice and judgment is actually awaited. That is the position. Now, as regards the first issue, with regard to tax paid and payable, I think the change is evident in the language itself. The language of the section now says tax paid instead of paid or payable, which means an actual payment of tax by the buyer to the seller is required. The second change is, according to me, a matter of substantive law. Now, the second change is that the buyer establishes that the tax has actually been paid by the seller. Now, this language, which is used in the Tamil Nadu Act, in my opinion, is something very similar to what was used in Section 48 of the Bombay Sales Tax, Bombay Value Added Tax Act, and which was the subject matter of discussion by a division bench of the Bombay High Court in the matter of Mahalakshmi stores. Section 48(5) of the Maharashtra Value Added Tax Act required the buyer to demonstrate that the tax has actually been paid by the selling dealer. Now, in that context, a division bench of the Honorable High Court of Bombay, that input credit being the concession, it is imperative for the buyer to establish the tax has been deposited by the seller. There could be a contrast in terms of the Delhi provision, which was dealt with later in the Delhi High Court recently, about a year back in Arise, where there was an option given to the buying dealer. The option being that he could demonstrate that whether tax had actually been paid by the seller, or that the seller has adjusted it against his output tax liability. Therefore, there was an alternative in the Delhi provision, which is absent in the Maharashtra provision. Now we have the Tamil Nadu provision. Question therefore is, are we closer to the Maharashtra's position, or are we closer to the Delhi position? If one goes strictly by the language of Section 19(1) of the Value Added Tax Act, Tamil Nadu Value Added Tax Act, it seems as if post 29/1/2016, we are closer to the Maharashtra position. Because the language of Section 19(1) as amended clearly states that the buyer has to establish that the tax has been actually paid by the selling dealer. Now, does this mean that the buyer has to establish and undertake the difficult task of establishing the tax payment? Now, fortunately, government has framed a rule. Now, in Rule 10, there is a small relief which is given to the assessee. Again, on the same date, which is on 29/1/2016. And the relief now given in terms of Rule 10 is to the effect that where it is deemed necessary by the assessing officer, the assessee will furnish evidence for payment of tax by the seller. Now, this is an important part of the provisions. You're able to hear?
Yes.
But I've lost the video. Just a minute, please.
Yes, sir. I'm able to hear you, sir.
Okay. Do you see me? I'm not able to see you. Just a minute.
No, my camera is off, sir.
Your camera is off?
Yes, sir.
Okay. I'm not
Now you can see, sir.
Okay. Just a minute. But I'm not able to see myself.
Sir, it'll be in the bottom. There'll be a smaller window.
Just
But all of us are able to see you, sir.
okay. All right. I'll just proceed that way.
Yes, sir. Yes, sir.
Okay. So I'll just proceed that way. Now, the important thing is, in terms of Rule 10 and the change amendment to Rule 10 with effect from 29/1/2016, the rule, in my view, reduces the rigor of the section. While the amended Section 19(1) requires the buyer to establish that the tax has been actually paid by the selling dealer, the rule requires the assessing officer to call for material where he deems it necessary. Calls for material as regards tax payment by the seller where he deems it necessary. Now, this to me is a relief given to the assessee by the government administratively. Now, it's not unknown that the section can impose a greater rigor than the rule. Section is enacted by the legislature, but administratively the government has given some relief. Now, the effect of the amended Rule 10 is that in exercise of power under Section 80 or 81, and as inbuilt mechanism under Section 27, the assessing officer can call for evidence, either from the seller's assessment circle, need not trouble the buying dealer straight away. He can call for evidence, and in fact, maybe duty bound call for evidence first from the seller's assessment circle, verify, call for returns and verify the tax payment. And only if he finds, if he's unable to gather information from the seller himself, then maybe he can go to the seller's assessment circle. Most probably the information will be available. If the seller is not responding, only at that stage, he can trouble the buyer and request the buyer to furnish proof of payment of tax by the seller. This is necessitated by the fact that the amended Rule 10 requires the assessing officer to call for information of tax payment by the seller where he deems it necessary. That's the language of the rule. So, in my opinion, even after 29/1/2016, and in spite of the amendment to Section 19(1) requiring actual payment of tax by the seller as a condition for the credit, Rule 10, as amended on 29/1/2016, appears to tone down the rigor of the amended section. This, I thought, is actually a welcome thing for purchasers, because very often in transactions running to several crores, correlation becomes almost impossible, because assessments are reopened after 5 years, as per the amended section as after 6 years, and maintenance of records is a problem. Very often we come across clients who say, records have been damaged in the floods, and the amended rule, according to me, offers much needed relief. Now, this therefore raises the question of a mechanism. Now, in JKM Infra, which is reported as volume 99 BST, page 343, the learned judge very correctly said that in matters involving mismatch, there has to be a mechanism in place first. Is there a mechanism which has been put in place by the department for cross-verification? Now, I understand that it is at a fairly advanced stage, and the mechanism is likely to be ready at any given point of time. But the suggestion was actually mooted by the court in JKM Infra in this 99 VST. Therefore, even after the amendment, question can arise in the absence of an effective machinery for the SSE to comply with, because the law casts an onerous burden on the SSE to establish a very difficult, to establish something very difficult, namely the tax payment to the seller. Now, if an adequate machinery had been put in place in the rules itself, it would have perhaps made the task easier for the SSE. Therefore, the question will arise: when, in the absence of a machinery, in place, can the amended section 19(1) be enforced at all? Now, in Arai's case, which is the judgment of the division bench of the Delhi High Court, which has now been affirmed by the Supreme Court by a dismissal of the SLP of the department, there were two arguments which were advanced by the SSE before the division bench of the Delhi High Court. Argument A was that section 92G of the Delhi Value Added Tax Act, section 92G of the Delhi Value Added Tax Act is invalid because it did not make a distinction between an SSE with a bona fide transaction and an SSE whose transaction could be questioned reasonably as sham. That was ground A. Ground B, on which section 92G was assailed before a division bench of the Delhi High Court, was that the condition of the SSE having to establish tax payment itself is onerous and violative of Article 14. The Honorable Division Bench read down the provisions and held the condition of payment of tax by the seller to be inapplicable in the case of a transaction which was bona fide. I would think that it may be perhaps far-fetched to challenge the condition itself as unconstitutional. Well, I'm aware of the division bench of the judgment of the division bench of the Gujarat High Court in the context of GST input credit, where they said that credit itself is vested right, and any attempt to lapse it would be violative of Article 300A. But then the lapsing itself is taking place on account of an act of parliament. Therefore, and in view of the judgments rendered in Jayam and Co., the line of judgments which have been coming recently in the context of Tamil Nadu Act, that credit is only a concession. Some difficulty can arise in challenging the validity of the provision as the condition itself as being unreasonable. But one can very well challenge any attempt to administer the condition as unreasonable in the absence of a mechanism. Therefore, ground A will be to challenge the condition itself as unreasonable, which in my view can face some difficulty because of the spate of judgments delivered against the SSE. Ground B can be that the administrative attempt to implement the condition without a mechanism in place is unreasonable and violative of Article 14. That can have some basis, especially in view of the fact that both the division bench in Mahalakshmi and the learned judge in JKM Infra required a mechanism to be put in place for cross-verification. So this is as regards the condition for payment of tax. Now, an incidental question was, can this condition be applied for all pending assessments? Tamil Nadu Act 13 of 2015 was brought into force on 29/1/2016. In my view, this is a piece of substantive law. It is not procedural, but it's substantive. The reason it is a piece of substantive law is that the SSE has, if the SSE had effected a purchase on a transaction which is admitted by the department to be not sham, but a genuine transaction, then the SSE gets a right to the credit. And requiring the SSE in respect of a pending assessment for the assessment year prior to 29/1/2016 to demonstrate that tax has been paid to the seller would be giving the section retrospective effect. Now, this is a piece of substantive law because it amounts to imposing a new condition or a disability on an existing right. Therefore, this condition would be only prospective and not retrospective because it will be a piece of substantive law. And in fact, held so by the learned division bench recently in this Vinayaga agencies, which I mentioned earlier. Now I'll come to the third part of the change, which is on the movement of goods. As I stated earlier, I'll have some reservation in taking one side or the other, but I can broadly indicate and have some difficulties because I think court is seized of the matter and judgment reserved. So I'll broadly indicate what was the submission of the SSE and the submission of the revenue. And I may not be understood as taking any particular side. As regards the submission of the SSE, the condition inserted, the second limb of the proviso to section 19(1) said that the goods have actually been delivered. Now the submission of the SSE was that this change has come only on 29/1/2016. Prior to 29/1/2016, I don't have to prove movement of goods. I only have to produce a tax invoice, was the submission of the SSE. A. That was in sum and substance a submission. The submission of the revenue, on the other hand, was that the sale itself is not complete without delivery of goods. The fact which is relevant to establish delivery of goods is the movement of goods. Therefore, it's not as if this condition, no question of retrospectivity arises here. That therefore, for all pending assessments, the SSE must necessarily demonstrate that the goods, that a delivery of goods has taken place. This was broadly the submission of the revenue. I thought I'll just indicate this without getting into detail with regard to on any other larger issue which was subject matter of debate before the court. Now, I also thought that this those three provisions, as I already said, I indicated the contrast between the Maharashtra provision and the Delhi provision and indicated that Tamil Nadu is closer to Maharashtra rather than Delhi. Now, I think this is broadly what I have to say with regard to scope of section 19(1). I thought I'll get into some connected issues under GST on mismatch, which I think will be of some interest and relevance for all of us. I think in one of the earlier sessions, there was a debate with regard to section 16(2)(c) and 16(2)(d) of the CGST Act. And the general view which has been expressed on behalf of advocates and consultants is that section 16(2)(d), which looks to furnishing of the return by the seller, by the supplier, which looks to furnishing of the return, looks to a return by the supplier and not the recipient, is the view which is being generally expressed by advocates as well as consultants. Now, Mr. Joseph Prabhakar expressed a contra opinion on the last occasion, and may say with very sound reasoning. I thought I would nevertheless sound something to the contrary to what Mr. Joseph expressed, and I'll give some reasons for that. I think the two reasons which were given to contend that section 16(2)(d) referred to the return of the supplier was that there is a semicolon which divides section 16(2)(c) and 16(2)(d. That section 16 itself is in two parts, that A and B is one part of section 16(2). C and D is another part of section 16(2). That C and D are essentially a scheme is the contra submission. Now is the contra argument. Now the contra argument is, look at 16(2)(c). It refers to payment of tax by the supplier. And after 16(2)(c, there is a colon. And that is followed by 16(2)(d). The colon is only an indicator of the continuation of the scheme under section 16(2)(c). Colon does not mean a complete full stop. It's only a connection between two interrelated sentences. Therefore, this is part of a scheme. 16(2)(c and 16(2)(d) are part of a scheme. This is the contra argument and reason A in the contra argument. Reason B given for the contra argument is, why have section 41? Section 41 requires the SSC to file a return. Why have section 41 at all? The scheme of section 41 itself becomes redundant and onerous if section 16(2)(d) is referred to return of the claimant. I think these two are essentially the reasons, I think, which were given for the contra argument. So what I felt was this. Now, when I went through some case law on this, fairly sound reasoning, when I went through some case law, fairly sound reasoning given for the contra opinion, but when I went through some case law, I found something attractive to still submit that section 16(2)(d) will only refer to the return of a recipient. I found two judgments, both of high courts, but with some discussion on the significance of a semicolon. One was a judgment in volume 96 VST, page 449, which is a judgment of the Punjab and Haryana High Court. The second is a judgment in volume 25 VST, page 546, which is a judgment of the Kerala High Court. Now, these two judgments discuss the significance of a semicolon and punctuation. What they appear to indicate is that the semicolon or punctuation is a connection between two parts of connected sentences. That's all it says. Therefore, it's intended as a bridge for two parts of the section. But whether the subject matter of the two parts of the section are the same is not determined by the existence of the semicolon. The semicolon may indicate some connectivity between two subsections, but whether they are indicative of the same subject matter may not be indicated by the semicolon. So what's the link between C and D? C refers to a return, D also refers to a return. What section 16(2) appears to say is that you as a recipient, if you require the credit, you ensure that your supplier has filed the return, you ensure that you have also filed the return. Therefore, the return scheme is set out under section 16(2)(d), 16(2)(c) and 16(2)(d). Return of the supplier in 16(2)(c), return of the recipient in 16(2)(d). Therefore, the existence of the semicolon is only indicative of a scheme, but is not determinative of the identity of the subject matter. So that's something which I want to point out. That's reason A, which I will give to still say that 16(2)(d) is only referring to a recipient and not the supplier. The second ground which was expressed for the contra opinion is section 41. If you look at section 41, it is not just a machinery for claiming credit. It no doubt refers to the fact that the buyer has to file a return, but it is something more. It provides a character or quality to the credit. Section 41, if one reads section 41 of the CGST Act, this is how section 41 reads. It says, every registered person shall subject to such conditions and restrictions as may be prescribed be entitled to take credit of eligible input tax as self-assessed in its return, and such amount shall be credited on a provisional basis to his electronic credit ledger. 2. The credit referred to in subsection 1 shall be utilized only for payment of self-assessed output tax as per return referred to in subsection. Therefore, the character and quality of the credit as a provisional credit is given to only in section 41 and not in section 16. Therefore, the uniqueness about section 41 is that it is not merely a machinery for availment of credit, but also provides a quality of a provisional nature to the credit taken. Therefore, therefore I would say that the contra submission that 41 may become redundant can possibly be questioned on certain grounds. That would be my very respectful response to what Mr. Joseph Prabhakar had expressed. So this is not something which I thought I'll just indicate. The second interesting issue which has arisen in CGST law is with regard to Rule 36. We all know that Rule 36 is under challenge before the Punjab and Haryana High Court, and now also before a division bench of our High Court. And one additional issue which has now come is the introduction of this proviso. Now, the question will be, now what does Rule 36.4 do? Rule 36.4 restricts the quantum of credit. Rule 36.4 restricts the quantum of credit at the hands of the recipient in respect of the transaction for which the supplier has not uploaded, and restricts the quantum to 10% of the transaction to which the credit has been, to which it has actually been uploaded by the supplier. Now, we can have conceivably a situation where I thought this specifically, I'll just bring it up, where the supplier has not uploaded part of the transaction, and it is not a condition precedent for the credit that it must be reflected in form GSTR 2A. Therefore, the recipient takes the credit and also uses the credit. Now, later on, because the time limit under section 16.4, the supplier has time, anytime until September of the succeeding year, to report his supplies. Now, I have time as recipient also to take the credit under section 16.4 until September of the succeeding year. If I demonstrate that the supplier has uploaded the balance transaction, then the credit revives. At that moment, the right to the credit revives, and then I'm able to, and then whatever credit I have taken and used gets sanctified. So the question will be, for the interregnum period, can there be charge of interest? Because though the supplier has not uploaded, I've taken the credit and used the credit. And once the supplier uploads, then the credit gets sanctified. For the interregnum period, am I liable for interest? Can be the question. In my view, there may be no liability for interest. Now, section 73 is the missionary provision for recovery of tax and interest, but it requires a charge. It refers to interest leviable under the Act. Unlike the erstwhile TNVAT rule, which says provisions of section 11AB shall mutatis mutandis apply for credit wrongly taken or utilized, 73 only looks to the interest leviable and interest payable under the Act. Now, the payability of interest is governed purely by the terms of section 50. Now, if one is able to point out a lacuna or a casus omissus in section 50 so as not to cover a scenario of this sort, then one can reasonably put up a case that during the interregnum period, between the period where the supplier did not upload and then later on uploads, there cannot be a charge of interest on the recipient assessee for alleged early claiming of the input credit. Reason A. B, one can also say it is not as if the credit itself is granted only when the supplier files. The credit is taken provisionally and the credit is used, and it maybe is kept in a state of suspension by the rule. Once the supplier uploads fully, then the credit completely resurrects. And I think these two reasons can possibly be given to submit against any levy of interest for the interregnum period. I thought these are the issues which I will broadly touch on. I think more or less, I think it's about 6-5. And I think I've dwelt on what I thought. I'll just put it across. Is there anything?
Yes, sir.
Yeah.
Thank you, sir. So now we will take up the queries from the
Sure.
participants,
Sure.
whatever they have to tell. So participants, if you have any queries, you can raise your hands in the app, or you can send a message in the chat box so that we can take your query. We can wind up the session by 6:30. So in the meantime, if there are any queries, you can raise your hands or drop a message. I'll unmute you.
I'm also wondering how I can get the screen back, actually.
Which screen, sir?
I'm not getting the video, actually. I'm able to hear your voice, but I'm not able to get the video. So
My camera is on, sir. There will be one more small window at the bottom of the screen.
which has a Zoom emblem.
Yes, sir.
It says open support chat is what it says.
No, that is chat box, sir.
Okay, all right.
Or in the bottom, there will be like many
Correct, fully charged.
sites. So in that, you go to page 2. If you're using your mobile, if you're using your laptop, then
laptop is what I'm using.
Then there will be a grid view itself, sir. There will be many boxes. And apart from us, everyone's camera is off, and except for Vijay Kumar, sir.
Okay, all right.
Yes, sir. Sir, Sundareswaran sir has a question. I'll unmute him.
I've got your. I've got the video.
Sir, I'll just unmute Sundareswaran.
Yeah.
Hello.
Yeah, please, Sundaresam.
ஒரு சின்ன டவுட்.
Yes, சொல்லுங்க.
It's just a doubt.
Yes.
That what is that? Interest under section 50, the decision rendered by Honorable Justice Ramasubramaniam is pending in review before the High Court.
Yes.
Did you have an occasion to see the order of it, sir?
Yes. I saw it, sir.
Is the review order correct?
So I think what has happened is the judges, I will put it with great respect.
Yes.
I think the one thing which I found is the judge went on the basis that when the return is uploaded, that's when the right is perfected. Was essentially the reasoning of the division bench in mega engineering. That the filing of the return was the one which perfected the right. I think there possibly a distinction can be drawn between the existence of the right and its exercise. Because why do we then have something called electronic credit ledger? The fact that the GSTR 2A is available and tax payment, automatically amount gets credited into the electronic credit ledger.
Yes.
I would assume that the electronic credit ledger is the depository of the credit, is itself indicative of the existence of the right. The filing of the return is only the exercise of the right. Therefore, I would think that's reason A. B, the other thing is one cannot ignore the commercial reality of credit being available in the books of accounts. Now, all limited companies maintain an input credit register. They have taken the credit already. Now if one taken the credit, now if credit, the passage in Eicher Motors, the one line in Eicher Motors, that credit is as good as tax paid, is something which is of relevance. In fact, Eicher itself was not cited before His Lordship Justice Ramasubramaniam or brought to his notice. Interestingly, sitting in Madras, one matter in which Mr. Viswanathan had appeared, there was a department appeal. And it's also reported. Again, judgment rendered by Justice Ramasubramaniam himself, but not pointed out when Mega was argued. He had taken the view that if the SSC had balance in the TNVAT credit ledger, he can't be treated as a defaulter for non-payment of tax or duty. So the judgment of the Madras High Court in the context of the TNVAT scheme was not even placed before the court, which decided mega engineering. That's the second part of it. There's also Apollo Tires and Fact India, two judgments of the Kerala High Court, which were again not placed before the learned division bench of the Telangana High Court. In Fact India, as well as in Apollo Tubes, the division bench of the Kerala High Court took the view. If credit is available in the TNVAT register, you cannot treat the assessee as a defaulter. There's a need for quantification and find if credit is available before proceeding to charge interest under section 11AB. I think there could be some fair basis to contend that there's some basis for some review before the division bench of the Telangana High Court. What I feel. And of course, the proviso, which is now newly inserted, some debate is on with regard to the effect of the proviso. Now, the proviso was not brought into force for some time. The question was, even during the period during which the proviso was not brought into force, proviso to section 50 is not brought into force, can it be given retrospective effect as clarificatory? Now, there are two ways of looking at it. If we can treat the proviso as clarificatory, that's one method. I think a better method will be that a proviso is intended to give relief. Maybe a piece of fresh legislation, but intended to give relief. And if it is intended to give relief, why draw an artificial line of a period prior to the proviso and after the insertion of the proviso? Can be fairly reasonable and sound argument. Now, it is true that the bringing into force of the proviso was left to the central government. But the notifying of the proviso by the central government is only implementation of the act. But it did not mean that the lawmaking process was not complete. And this issue has been elaborately discussed in the year 2012 by a constitutional bench, which went from Kerala, case which went from Kerala. The way the constitutional bench, headed by Justice Kapadia, said that the lawmaking process is complete, but it's only the implementation of the act which has been left to the delegate. I would therefore assume that once the Finance Act was received presidential assent, the Finance Act which inserted the proviso received presidential assent, the lawmaking process itself was complete. The lawmaking process itself was complete, and the implementation was only left to the government. Therefore, one can reasonably contend that the proviso already has the force of law, and therefore can be applied even for pending cases. This is what I feel can be legitimately, can be with some basis can be put across in a court.
Difficulty
Maybe
will be what
contra
will happen, but the difficulty will be what will happen to the amount already collected by the department. That is where we stand.
That is true. That can result in one of two consequences: either an appeal by the department or a further retrospective amendment to section 50.
Or can be validation.
That's what I'm coming to, a validation.
Thank you so much, sir. Thank you.
So, Joseph sir wanted himself to be
Yes,
unmuted.
please.
He has put up a query in the chat box also, sir.
I see. Okay. Oh, yeah. Now, how do I view the chat box?
So, you saw that sign, no, sir, in the
Just a
bottom
minute.
chat.
Just a minute. Just a minute. 1 minute. 1 minute. So,
But I've anyways unmuted Joseph, sir.
okay, please. Sorry, Mr. Joseph Prabhakar, please tell me what the query is. I'm not able
No,
to.
I thought if you probably can read that for a minute.
I see. I'm so sorry. I'm not able
Or
to.
if you want me to read out, sir?
Yeah, please.
I'll read it out.
Yes, sir, Joseph.
See, actually, on 1/7/2017, when the CGST came in,
Yeah.
Section 16(2) contained four conditions.
Right.
There are not major amendments except for an explanation, all that.
Right.
Until today, that four conditions remain the same, largely.
True.
And all that.
True.
Now, for a minute, please presume that as on the day of introduction on July 1, 2017,
Yeah.
condition D was not there. It ended with that semicolon full stop.
With C.
And
Yeah.
D was not there at all.
Right. Okay.
3, A, B, C and C.
Yes. Okay.
Now I want your answer, a very simple yes or no.
Yeah. Yeah.
With these 3, because there is no condition at all.
Correct.
If the condition is there, we are compelled to interpret who is the he, whether the supplier or the
True.
the recipient or the person availing the credit.
Correct.
There at all, there is no condition of return at all.
Correct.
ITC credit.
That's true. Yes.
Scenario,
Yeah.
my question to you is whether
Yeah.
recipient could
Yeah.
avail the input tax credit
Yeah.
without filing a return in form GSTR 3B, because the term the form GSTR 3B, why I say is because D refers to return in form 39.
Correct. Exactly. Yes.
One return, either it is 3, temporarily now 3B.
3B. Correct. Yes.
So you have to read it as 3B. So,
Yeah.
question to you is, would a recipient be in a position to avail the credit, take and utilize, or take the input tax credit and utilize the credit without filing return in form GSTR 3B? Yes or no?
He would not be in a position to take the credit.
Yeah. If that is so,
Yeah.
that not stating the obvious in having.
Therefore, there's a need for a mechanism. Therefore, there's a need for a mechanism to enable him to take the credit.
Yes.
And because we need a section which not only declares the right, but also provides for a machinery to avail the right. Therefore, section 16.2 will not only recognize the existence of the right, but it requires the existence of section 16.2e, which is to indicate the mode by which the right can be availed. Therefore, 16.2d was necessary as the mode by which a claim can be made. You see, there's a claim which is necessary before a right can be asserted. Somebody can say, I've taken it in my books of accounts. Now, how does he put in motion the machinery of the law without the help of a return? Maybe there could have been a different return instead of GSTR 3B. But he requires the force of law to set the machinery of law in motion. And that machinery is set in motion by the recipient as a machinery to claim credit by subclause E. I would prevent, otherwise somebody can take, now let's take for example, the time limit. If you take for example section 16.4, it provides for a time limit. Somebody can say that I have taken the credit in my books of accounts within time, though I may not have filed a return. Now, to prevent extreme arguments of this sort, the law provides for a scheme. The scheme is that there is credit and there's a method indicated for availment of the credit. I would therefore believe that 16.2d was necessary as a mechanism to claim the credit from inception.
If you read section 16d, it says, he has filed the return under 39.
Furnish the return under 16.
Furnish the return under 39. So, when a person can't claim the credit without filing for the return under 3B, why the legislature states that obvious? That is one. Secondly, the quality. You went to 41. Then said for 41 talks about the quality, but actually 41 closely. With great respect, I would like to differ because quality 41 is also
it can even be.
You read 41. It is not quality, but also quality. I read 41 for you.
Absolutely right.
Every registered person shall subject to such condition and such restrictions. May be prescribed, be entitled to take the credit. Please note, entitlement to take the credit comes in 41. Credit of the eligible tax, as self-assessed in his return. Then it talks about the quality. It does not say if there only quality to have said every person shall be entitled to take tax credit on a provisional basis. Simple. There is a need to say take the credit in his return to say that the credit taken thereof will be provisional. That is, if you also look at subsection 2, independent of section 1, subsection 1 of 42, 41, it says
Yeah.
the credit referred to
Yes.
section 1
Yeah.
shall be utilized
Yes.
only for payment of self-assessment output, self-assessed output tax
Output tax.
as per the return. That
Yeah.
means, like the Rule 14 TNVAT Credit Rules 2014, now
Yeah.
they have to draw the distinction between
Yeah.
availing and utilizing
True.
two components. For availing, there is a return mandatory.
Yes.
For utilizing, there is a return mandatory.
Yes.
The return referred to in 41 is nothing but the return referred to in 39, which is
True.
nothing but 39. It's a
True.
TB. Now,
Yeah.
if you read GST, the 16(2)(d),
Yeah.
he has furnished the recipient. If you read D, if you say, if your version has to be accepted, that it is only recipient, and if you have to read the section,
Yeah.
yes, if the and if and instead of he and the recipient has furnished GSTR 3B return.
Yeah. Yeah.
Why would they say this?
Yeah.
They have said it so elaborately in 41, 1 and
Yes. Yeah.
and why would they say that if without filing 3B, the recipient or the person, the registered person can never avail the ITC. Therefore, I am not relying on the semicolon alone. Semicolon cited as one of the reasons by somebody. So I only break the argument that semicolon, that he is.
I follow. I follow.
Is the same thing.
Yeah.
The full stop comes and then closes. So
Correct.
you can't presume that the D is ABE. The D, he in the D.
I follow. I follow. I follow, sir.
Independent of that, we'll have to establish. That's why I went to 41, 1 and 2, and this thing.
Yeah. Yeah. I follow.
Thanks.
Yeah. Now, one thing which I found, what I found just as you were reading the section, something which occurred to me.
Yeah.
Now, if you look at section 41,
Yeah.
there is no mention of a condition at all. 41 itself doesn't spell out any condition.
Yes.
16.2 is a section which spells out conditions.
Yes.
Now, therefore, you can have conceivably a situation where both 41 and 16.2D refer to the return of the recipient. 41 is the method of taking of the credit, and 16.2D is the condition for the credit. In other words, though you can reasonably say, is it not possible to reasonably say that section 41 is the mode by which the credit can be availed by the recipient, while 16.2D treats that mode as a condition, that very mode as a condition.
No, 41 refers exclusively to the registered person availing the credit, or the 41 can never refer to the supplier.
No, not at all. I'm only referring to the recipient. I'm saying
41, 1 and 2
absolutely
only to the registered person availing the credit.
Absolutely. Therefore, 41 doesn't set out any condition by itself. It is section 16.2D which treats the filing of the return as a condition. Therefore, we can have conceivably a situation where both 41, I am saying that both 41 and 16.2D can refer to the recipient. The distinction being twofold. A, as I said, 41 also gives a quality to the credit. B, one other reason. One other reason is 41 does not treat the filing of the return as a condition, but 16.2 treats it as a condition. Therefore, both 41 and 16.2D can conceivably refer only to the recipient. The distinction being under 41, it's the mode or method, while under section 16.2D, it's a condition.
Sir, I would just interrupt for a minute here. I think we have found a point for discussion. So I would call in participants who want to
carry on, Pradeep. Sorry.
No. Sir, you can come in. I'm just inviting participants if they have some other view also on this.
On 16.2D. Yeah, correct.
Yes, sir. So, but before that, we can ask Aparna ma'am. I think she's having a query for a long time. So we can start with that, and then we can come back to this. So in the meanwhile, if participants want to supplement on this point under section 16.2D, you can raise your hand. This can be a good point of discussion today. So I will just unmute Aparna ma'am first.
Please.
No, I don't have much to say, except that it was a fantastic presentation, Prasad. See, you rightly touched upon the Maharashtra VAT Act, which actually forms the basis of the GST.
Yeah,
It's absolutely fantastic. I don't want to comment on that 16.2D right now because of the position that I am in.
I follow.
Fair enough.
But it's a fantastic debate. Yes, it is going to create a lot of confusion whether it is a supplier or the recipient. Yes, definitely. But I don't want to say much more on that. But I just want to compliment you that it was a fantastic presentation.
Thank you so much. Thanks for the opportunity more than anything else. It was wonderful meeting all of you. There's been a 2-month break. Nice to talk to all of you.
Yes, sir. I think Sundareswaran sir had a few points. He put up the points in the chat box, but I'll unmute him.
Yeah, please.
Hello.
Yeah, please.
Sundareswaran sir.
Yes.
And Jay Kumar sir also, I believe, have some point. I'll unmute him also.
Yes, please.
Hello.
Yeah, please.
Unless the return is filed by supplier,
Yeah.
how does the mechanism work for the buyer to avail the ITC? It can't be done. It is not possible at all. A common man sense, it is not possible at all. So the reference to 16.2D can only refer to the return filed by the supplier, not by the buyer. It can't be.
But 16.2C,
because 16.1 speaks about the right to avail the ITC. So he has to file a return. The availer, that is the buyer, has to file a return.
Absolutely.
In order to corroborate it, the return should be filed by the supplier. Only then it works out. If not, it won't work.
But that requirement is supplied by section 16.2C itself.
Yes.
Because you cannot have payment of tax without filing of return.
Absolutely.
Therefore, 16.2C itself, sir, takes care of possibly the contingency you are mentioning.
Yes.
Therefore, 16.2D will necessarily refer only to the recipient. Because payment of tax is referred to, if I read 16.2C, because we've been dwelling on 16.2D so far.
No, Prasad, I think there is some, I think a very, very, very basic point over there.
Yeah.
Let's say I buy something from Sundaresan.
Yes.
Sundaresan charges 1,000 rupees plus 18%, 180 rupees.
Correct.
He also has sold goods worth 15,000 rupees or 55,000 rupees to some ABCDXY.
Correct.
He can pay the tax relating to my supply on.
Yeah.
He will not be in a position to file his GSTR 3B. He files, unless he pays the tax for all of his supplies, he will not be in a position to file 3B. So, your assumption that tax paid will automatically mean return filed, that proposition is not correct. He can afford to pay tax, he may pay tax, unless he pays tax in full for all of his supplies for that particular month, he will not be able to file the returns. That is why they are making me, the recipient, very onerous condition. I have to ensure that the other side, they pay the tax. I have to ensure that the other person complies with this tax requirements or compliance properly, which is extremely onerous. But that is how the law reads today. I'm not saying it is good, bad. I'm only saying how.
I follow what you're saying.
Yeah, so there is a factual situation that under the GST law.
Yes.
And I will place a order, he will supply. I
understand.
Entirely, he can still pay that my portion of the tax, electronic cash ledger, but he may not be in a position, he will not be in a position to file 3B for that month. He pays all of the taxes for all the supplies made in that month.
Right.
The reason for this D.
Yeah. There's also one more thing. If they had in mind the supplier, the expression supplier is actually found in section 16.2 itself. Just have a look at section 16.2. There's one more reason.
No, but vice versa, if it is a registered person, there are registered person is referred to in more than 4 places than the supplier. 16. The same logic, if you see, right?
Understand.